Good morning, this is your Kelso Report for Tuesday, February 5th, and I'm your host, Clark Kelso. We begin today with a Ninth Circuit decision approving the restarting of mining in an Arizona mine pursuant to a 17-year-old government approval. The California Supreme Court has affirmed another death penalty, and it issues an important decision limiting the applicability of the Song-Beverly Credit Care Act to online transactions. We close today with a California Court of Appeal decision interpreting the FTC's holder rule as applied to consumer installment sales transactions. Let's first start with the Ninth Circuit. For how long does an approval of a mining permit for the Bureau of Land Management last? That was essentially the issue in Center for Biological Diversity v. Salazar, where an environmental group challenged the decision by the Bureau to permit a private mining firm to restart its mining operations at an Arizona mine in 2009, pursuant to a plan of operations the Bureau had approved in 1988, essentially starting the mine again after a 17-year hiatus. The Ninth Circuit affirmed the trial court's decision in favor of the Bureau. The plaintiffs had argued that by stopping their mining operations, the 1988 approval expired as a matter of law. But the Ninth Circuit could find nothing in the statutory provisions supporting that position, and some of the language clearly suggested that a lengthy project could stop and start without requiring fresh environmental approvals. In short, the mere passage of time did not affect the legal effectiveness of the 1988 approval, and mining operations could lawfully restart in 2009 without further environmental review. Next, the death penalty decision. California Supreme Court affirmed a capital sentence in People v. Whalen, with 6 justices joining the majority opinion and Justice Liu concurring separately on one issue. A jury had found the defendant, Daniel Lee Whalen, guilty of the 1994 first-degree murder and first-degree robbery of one Sherman Robbins, and found true the special circumstance allegation that the murder was committed during the course of a robbery, as well as the allegation the defendant personally used a firearm in the commission of the offenses. The defendant admitted he had suffered 3 prior serious felony convictions and had served 4 prior prison terms. It took the California Supreme Court about 120 pages of analysis to affirm the verdict and the sentence. Now we have a consumer protection decision from the California Supreme Court. The explosive growth of online transactions has quickly surpassed our legislature's ability to update pre-internet consumer protection statutes to the new realities of retail sales. A perfect example is the Song-Beverly Credit Card Act of 1971, which governs the issuance and use of credit cards in California. Concerned about privacy rights, the legislature added a provision to the act in 1990 that prohibits retailers from requesting or requiring, as a condition to accepting the credit card as payment, the cardholder to write any personal identification information upon the credit card transaction form or otherwise. It also prohibits retailers from requesting the cardholder to provide personal identification information which the retailer writes, causes to be written, or otherwise records, or from utilizing a credit card form which contains pre-printed spaces designed for filling in any personal identification information. In Apple Inc. v. Crescent, a consumer complained that Apple had violated these provisions by requesting and requiring him to provide his address and telephone number as a condition of accepting his credit card as payment in an online transaction. Recognizing that the pre-internet amendments to the Song-Beverly Credit Card Act were entirely premised upon a brick-and-mortar sale and face-to-face transaction involving credit card forms, remember those? The court held in a close 4-3 decision that these provisions of the Act simply did not apply with respect to an online sale for an electronically downloadable product. The dissenting justices expressed concern that the majority was sacrificing consumer privacy, but I think the majority is correct in thinking that it really should be up to the legislature to determine how and whether to protect consumer privacy in the context of online transactions. The members of the court are not in a very good position to try to balance the relevant interests, much less to understand how the technology of online transactions actually functions. That's a conversation that online retailers and their representatives need to have with consumer groups and privacy advocates and the credit card industry in a legislative context. Finally, we have another consumer protection decision, this time from the California Court of Appeals. When a consumer buys a product pursuant to an installment sales contract and the seller then assigns that contract to a lender, it can put the consumer at a significant disadvantage, since the consumer is no longer dealing with the retailer with whom it dealt. It is instead dealing with a financier, typically a bank, which has a very different interest than the retailer had. In order to help level the playing field, the Federal Trade Commission has promulgated a regulation known as the Holder Rule, which, in general terms, is designed to make the lender subject to claims that could be asserted against the retailer. In Lafferty v. Wells Fargo Bank, the 3rd District interpreted the Holder Rule in the context of the installment sale of a motor home that turned out to be defective. When the retailer failed to make demanded repairs, the buyer sued the retailer and the bank, which had been assigned the installment contract, for breach of contract, violation of the Consumer Legal Remedies Act, and negligence. The trial court dismissed all of the claims against the bank, reasoning that it could not be held liable for claims that pertained only to a breach of the responsibilities of the seller. Well, the 3rd District reversed. The plain language of the FTC regulation provides that, quote, any holder of this consumer credit contract is subject to all claims and defenses which the debtor could assert against the seller of goods or services obtained pursuant hereto, close quote. So the bank, by the terms of the contract and the terms of the FTC regulation, was subject to all of the claims that could be asserted against the retailer. There was only one limitation on those claims provided for by the federal regulation, namely, quote, recovery hereunder by the debtor shall not exceed amounts paid by the debtor hereunder, close quote. In other words, the Holder Rule gives the consumer another responsible party to hold accountable, the bank, but limits that recovery to amounts paid by the debtor so the lender is not put at risk beyond the extent of its credit. A fair trade-off and a fair result to protect the consumer's interests. And that's it for today's Kelso Report. Have a great day in the law.